friends, welcome to the channel. This is your Govindraj. Thank you very much for watching my previous videos. And today we are going to talk about an important topic with related to higher pension. See, one of the important question which is being asked very frequently to the experts and also the speaker on this subject is whether people who have continued after 1/9/2014 but they have contributed on higher wages before 1/9/2014 but their contribution is restricted to the ceiling wages which is 6,500 or 15,000 after 1/9/2014, are they eligible to exercise the option for higher pension even though they have not filed the joint declaration under para 26(6) of the EPF scheme 1952? And this is the question which is being frequently asked to the speakers and experts. Now I'm going to deal with this topic in this video, and before that friends, in the last 2-3 videos I have introduced this book called Managing Labor Relations, which is authored by me and which is very helpful to all people who manage the people and labor in their shop floor, also in their offices. And this is a book of management and also law, and this will definitely help. And this is currently not available in online. In case you would like to have a copy, you have to talk to me or send your details via WhatsApp to me, and then I will be able to dispatch this copy to you. Now friends, let's come to our topic. See, if I at all I have to give you a brief about this topic, I have to give you certain background. See, if I don't give you a background, then probably you will not be able to connect to the topic. So let me give you certain background. See, when you decide the eligibility to become higher pension, you have to consider the provisions of EPF Act, EPF scheme, and also EPS 1995 and arrive at your conclusions. And if you jointly read these provisions, there is something called excluded employee under para 2F of the EPF scheme 1952. And as per this para 2F, if any employee's salary exceeds the wage ceiling, and which is currently 15,000 and before 1/9/2014 it was 6,500, and when he is entitled to become the member as per the PF and Miscellaneous Provisions Act 1952, he is treated as an excluded employee for the purpose of the scheme, and such employees are not entitled to become members of the provident fund. But if he is already become the member because of the wage ceiling criteria and later his salary exceeds, he will continue with the fund. This is very clear. And for the excluded employees, there is a way out given in the para 26(6) of PF scheme to cover such employees under the scheme, and also if their wage ceiling exceeds, to contribute contributions for more than the ceiling wages. So this provision, and there is a way out is given under para 26(6) of EPF scheme 1952 and not EPS scheme. And the way out is to seek permission from Assistant Provident Fund Commissioner or the other higher officer by filing a joint declaration to enroll an excluded employee and also to contribute provident fund for more than the wage ceiling. So this provision has been given. But in practice, what employees and employers are doing or have done, that they started covering excluded employees under the scheme and started contributing on higher wages without complying to the provisions of para 26(6). And if you look at para 26(6), it is very clear that there is a joint request is required, there is a permission is required to cover the excluded employee and also to contribute more than the wage ceiling. So therefore, a joint declaration while enrolling an employee drawing more than 15,000 wages, and also when you contribute on higher wages, it is a mandatory process as per para 26(6). Now if you look at EPS scheme 1995, let's also see how it is connected, this provision is connected to EPS scheme. Until 1/9/2014, excluded employees, that is employees whose salary exceeded the wage ceiling, were not excluded from the scheme. Only with GSR 609E from 1/9/2014, the salary ceiling was introduced to cover the employees under the EPS scheme. You can read para 6A of the scheme, you will find that this wage ceiling is introduced. Also, until 1/9/2014, the proviso to para 11.3 gave an option to contribute to EPS at higher wages at 8.33% of employer contribution, and their higher salary will become the pensionable salary for such employees. In the case of RC Gupta and others, their employer contribution was remitted on actual salary, and the RC Gupta and others, they were unaware of the option under proviso to para 11.3 during their working time. They took the plea before the court to consider their higher contribution to EPS, and they also asked for higher pension. And the version of EPFO on paragraph proviso to paragraph 11.3 and the interpretation in RC Gupta's case, all this we have seen in the previous videos. Therefore, my request for you is to also watch these videos for understanding of this interpretation. And in the case of RC Gupta, it was held that once the option under para 26(6) is exercised, exercise of separate option is not necessary for EPS for higher contribution. So this was held in RC Gupta's case. Now our question is, what if there is no formal joint declaration is filed by employer and employee under para 26(6) of EPF scheme, but both contributed to PF on wages exceeding the ceiling, but the contribution to EPS is restricted to the ceiling wages, which is 6,500 before 1/9/2014, and after 1/9/2014 is 15,000 rupees. Now, are they eligible to exercise the option in view of the recent Apex Court judgment within 4 months from the date of judgment is our topic. Now, to answer this question, friends, we also have to aware about the events which occurred after the RC Gupta case. And in one of the circular of the EPFO dated 22/6/2019, the EPFO cleared that the deemed exercise of option. So therefore, let me read it for you, the circular gist of it. If an employer and employee have contributed under the EPF scheme 1952 on wages higher than the statutory wage limit without joint option of employee and employer, and the EPF account of the concerned employee has been updated by EPFO on the basis of such contribution received, then by action of employee, employer and EPFO, it can be inferred that joint option of employee and employer has been exercised and accepted by EPFO. This is, I am not saying, the PF department is saying in one of their circular, which was clarified after RC Gupta case. Even in RC Gupta case, if you take in para 10, if you read, the court said, the Supreme Court said, in a situation where the deposit of the employer share at 12% has been on the actual salary and not the ceiling amount, we do not see how the Provident Fund Commissioner could have been aggrieved to file the LPA before the division bench of the High Court. So this is the exact word of the RC Gupta case. Now, can EPFO go back from their stand of this stand who continued beyond 1/9/2014 and deny the higher pension option for them is the point. Now, in my view, they cannot do this. But there is definitely a scope for EPFO to take the stand that there should be a formal joint declaration as per para 26(6) of the PF scheme 1952 and express permission to avail this benefit. So people who have not formally filed a joint declaration and there is no express permission, then they can say there will not be any option for higher pension. This is possible. But if at all this happens, friends, the majority of employees who contributed higher wages, who contributed on higher wages before 1/9/2014 will not get the benefit under this judgment. But this will definitely invite a fresh set of litigations against EPFO. Therefore, I am hoping that the EPFO will continue the stand of deemed exercise of the option when it is continued by action of EPFO, employee and employer under para 26(6). Currently, friends, the guidelines from EPFO are not available, and I am sure in the future few days the guidelines are going to come, and I will keep you posted in my channel. And if this video has helped you to understand this topic very clearly, I would ask you to subscribe the channel if you have not done, and also share this video with your friends and colleagues. And thank you for watching this video, and see you soon in the next video with next update, friends.